SJC-11503, Commonwealth versus Velez.
Mr. Reardon, good morning.
Good morning, Your Honors. Theodore Reardon on behalf of the defendant, Mr. Velez. The issue before you today, Your Honor, is whether or not there is a substantial likelihood of a miscarriage of justice when trial counsel pursued a third-party culprit defense rather than mental health impairment and intoxication. The information available to trial counsel on his mental impairment was that his issues started at age 15 in 1997. In the next 13 years until 2010, when this incident took place, he had extensive outpatient counseling. He had 3 psychiatric inpatient admissions, including 2 4 months before this incident. And the records clearly show that his mental health issues are greatly exacerbated when he ingests drugs and alcohol. Both of his suicide attempts and his thoughts of committing suicide on the 3rd time involve his ingestion of drugs and alcohol. On the issue of his ingestion of drugs and alcohol on this night, the evidence shows that in the 2.5 to 3.5 hours before this incident, the defendant consumed a minimum of 5 to 6 beers and had cocaine. That's corroborated by the drug testing that was performed 2 hours after this incident in the hospital, which tested positive for cocaine and a blood alcohol level of 0.96. The emergency room doctor talked about extrapolating backwards what his blood alcohol level would have been 2 hours earlier at the time of this incident, and using that doctor's methodology, his blood alcohol level would have been 0.146. So there was more than enough information to pursue these defenses, mental impairment and intoxication.
Don't we really have just 2 bad defenses?
I'm sorry?
Don't we just have a choice between 2 bad defenses?
I don't think so. I think you have a choice between a very viable defense and no defense at all. The third-party culprit defense had no possibility of success. The most compelling reason about that is the blood splatter evidence. The Commonwealth had an expert testify that at the time of this incident, there was blood on the defendant's pants from one of the victims. And that expert testified that the defendant was no more than 2 feet away at the time of this blood splattering event. And for some inexplicable reason, defense counsel had his own expert that basically testified to the same thing. That expert testified the defendant was in close proximity at the time of this event. And of course, the defendant's version was that he came across the scene from the other side of the bedroom. He saw the bodies dead on the floor. The stabbing had already taken place, and the perpetrator, under one version, was standing over victim A, and under another version was standing over victim B. But in either event, the stabbing had already concluded.
Can I ask, I had to do sort of a mind shift because you're sort of presenting how bad the defense was. But the blood splatter, is there any other interpretation in the light most favorable to the defendant that it didn't show that it was Bennett's blood splatter? I thought the blood splatter stuff was a little more murky than you describe it in your brief. It's absolutely conclusive that it's blood splatter from Bennett?
I don't think there was any question about that.
All right.
Yeah.
So the 2 things that are conclusive is that Bennett's fingernail has his DNA on it, and blood splatter from Bennett is on him, right?
Yes, and on the fingernails, the DA made an argument to the jury that that was the most compelling evidence in the case.
And how does the defense counsel deal with the blood splatter at trial?
He makes an argument, some vague argument and closing argument that, well, given all the blood at the scene, who knows how it got on the pants. But in light of his own expert testifying, the pants were present at the time of the blood splattering event. I don't know how he could possibly make that argument.
Well, he called the expert, I assume, for a reason.
I can't imagine what it was.
There's no discernible reason for him calling his own expert on the blood spatter?
Yes. Yes.
What was the knife that was used to stab Ortiz?
I'm sorry, one more time?
How was Ortiz stabbed? There's a knife that was found in the sink that had blood from the defendant and Bennett, correct?
Yes.
No blood from Ortiz, no indication that there was that was the same, or was that the same murder weapon that was used on Ortiz?
Well, the DA made an argument about that at the closing, and the DA's argument about that was the knife was found in the sink, the kitchen sink, and so the DA's argument to the jury was that the defendant had washed it off, and that's why Ortiz's blood was not on it, and I'd go with that version.
So you basically, you take the Commonwealth's closing argument and
Absolutely, yes. And the DA, of course, is backtracking in the appellate level now on all those arguments, saying they were awful arguments, and the defendant had a great argument, but
that's why this is
Yes, yes, yes.
topsy-turvy.
I mean, you don't have an enviable task because you have to prove that the strategy chosen by defense counsel was manifestly unreasonable. He did have Gonzalez admit to somebody that he had committed the murder. Most cases don't get something that good. Plus, he had a motive because of his animosity towards one of the victims. So why? And then you would have had to deal with the fact that the police officers who interviewed him would have said. Plus you also had the $10,000 ripoff. So you had two things of motive, that Ortiz stole his lady while he was in jail. You've got the $10,000. You've got him saying to Begg that he admitted to the killing.
You also threatened to kill him in advance.
And on the other side, you will have had, and the defense counsel would have had the opportunity during the motion to suppress hearing to hear the officer's characterization of what they saw when Velez spoke with them after the killing, which would not suggest that he was as out of it as a result of drugs and alcohol as you would describe. So why is it manifestly unreasonable to go with the third-party culprit as your better of the two alternatives?
I'll make the argument the DA made in closing. The defendant, Gonzalez, had, at the time, he had an unimpeachable alibi. There was CSLI evidence showing his cell phone was in Lowell. There was video showing he was in Lowell. He had multiple witnesses showing he was Lowell. There was no evidence that he had the means to procure someone else to do this. He had just been released from jail, I think 6 months earlier. The bail that he had posted on that had been posted by, I believe it was Bennett's mother. There was no indication that he had the financial means. In addition, his car was, he couldn't make his car payments when he got out of jail. So there was no evidence that he had any means of hiring someone else to do this. And in addition, there's no evidence that he knew of anyone who would go around committing a murder. So that was the argument that the prosecutor convincingly made at trial, and I would adopt it.
Which way into this equation the fact that you're now asserting the better defense would have been diminished capacity?
Yes.
As opposed to a not guilty on third-party culprit?
I don't think there was any possibility of that third-party culprit defense succeeding. And in this case, there was a possibility of not guilty because the jury was not charged with manslaughter. So it was either going to be a guilty or not guilty on the murder.
Did the attorney ask for a manslaughter instruction here?
I don't believe so, no. No.
Because he rested on the third party, which was inconsistent with the claim of alcohol and drugs as
Yes.
defense.
Yes.
So even if you get past the manifestly unreasonable prong, then you would still need to show that there was a substantial likelihood of miscarriage of justice here, which would mean that you would have had a meaningful chance of prevailing on second degree or involuntary. And tell me how you think, given the quality of the evidence you suggest would have been presented, that is something which raises a substantial likelihood.
Well, the intoxication and the mental health defenses both negate malice And so he wouldn't be convicted on either murder one or murder two.
And in theory, I'm saying with
Yes.
regard to the problems you have in terms of the weight of that evidence as described in the Commonwealth's brief and as reflected in the judge's findings on the motion motion to suppress, why should we have any reason to think that a jury would have been affected by that defense had it been offered?
Well, the motion to suppress, that concerned the issue of voluntariness on the confession the statement that was made by the defendant hours afterwards. And so there, contrast that with the undisputable evidence that from the hospital about the defendant's cocaine level and ingestion of alcohol, and you couple that with the Commonwealth's own witness, David Ortiz, who testified about everyone was ingesting alcohol before this.
He's fully functional before this inexplicable event, right? I mean, he's driving around, there's this bizarre thing where they're gonna go have some retribution against another guy, and they're partying and going back and forth. It's not like he's a zombie.
The defendant was not driving. David Ortiz was doing the
Right,
driving.
but I'm saying they're all out and about. They're doing things before. Because one of the reasons that I think the motion judge found this way was the third party makes sense because it's kind of an inexplicable event. Because you have these people, there's no animosity, and all of a sudden the two people are dead.
Well, yes, but I think that goes to support the mental health and intoxication defenses that this is an inexplicable incident. The weakest of motives presented by the Commonwealth was that the defendant's feeling towards
Who knows? Because
right. Yes.
we have three people living together, and all of a sudden two of them are dead.
Oh, the defendant was not living there. He was just an overnight guest.
I misspoke. He was staying. He was allowed to stay over, right?
Yes.
But there's no hostility that I saw, right?
No, but that, I suppose that cuts both ways
guess.
at best, in that it goes to show that, why would the defendant do this other than that he had mental health and intoxication going on. So, and I would add to that, Your Honor, the preposterousness of the defendant's version about how he talks about how he had this life and death battle in the hallway outside the bedroom. And yet there was all this evidence that there was nothing disturbed in the hallway. The defendants claim that after the perpetrators fled, that he goes and inspects he goes and washes up. Then he goes back into the bedroom and searches for a tourniquet, some cigarettes and a cell phone, then goes washes up again. And then he goes and tries to ingest crack and light a cigarette, and has some beer, and then he decides to call the police. I mean, I can't imagine any jury believing that version of events that the defendant said to the police. So for all those reasons, I don't think there was any possibility of success on the third-party culprit defense, and the only defense was the mental impairment and intoxication, and I don't think they were weak defenses. They had a lot of legs. And the last thing, if I can ask you, Your Honors, it's a little unclear on bringing these motions for new trial on first-degree cases about the standard that the trial judge should apply on an ineffective assistance claim. In this case, the judge applied the Safarian standard. I think it could use some clarity that whether or not the Safarian standard was satisfied, as the judge ruled on, really is not relevant to this court because this court uses the Mercado standard. And so...
I'm sorry, uses the which standard?
Mercado,
Mercado?
yes.
Which...
The substantial likelihood.
Well, yeah, but with regard to strategic choices, you still have to show it's manifestly unreasonable. Yes, with regard to the failure to object in errors of law, you may go straight to substantial likelihood, but where the question is not an error of law, but the strategic choice of counsel, haven't we consistently used that you first have to show it was manifestly unreasonable before you get to substantial likelihood.
What I'm saying, Your Honor, is that as at the trial court level, the judges, when I've asked them in the past to apply the substantial likelihood standard, because that's the standard that you would be reviewing, the response I've gotten is that they're just going to look at the Safarian standard.
Well, I understand that may be an issue in some cases, but with regard to strategic choices, that seems to be accurate because we employ prong one. We still need to find that it has to be manifestly unreasonable before we reach substantial likelihood, which differs if, for instance, the defendant failed to object to something and there was an error of law, then we'll go straight to substantial likelihood. But we don't do that for strategic choices.
And we wouldn't expect the trial judges to apply 33E review, right?
Well, the court does in the Rule 25 motions, just on the question of if the court was reviewing whether or not the trial judge correctly decided the Safarian standard was met, it wouldn't, in some circumstances, matter because this court would be applying the substantial likelihood standard. If there's no further questions.
Okay, thank you. Ms. Langsam, good morning.
Good morning, Your Honors. May it please the Court, my name is Jessica Langsam. I'm an Assistant District Attorney for Middlesex, appearing on behalf of the Commonwealth. And with respect to the standard of review issue that counsel just raised, well, a Superior Court judge could, I suppose, apply the substantial likelihood of miscarriage of justice standard. It doesn't make sense where a motion judge is tasked with reviewing motions pursuant to Rule 30 that contain a limited number of claims that defense counsel asks the court to view. Obviously, this court's review is broader under 33E, could encompass additional issues, and where, as Your Honor, Chief Justice Gans has pointed out, just the trial judge or the motion judge here did look at whether or not trial defense counsel's strategic choice was manifestly unreasonable, and that's really the same test. So it's sort of where the trial judge is looking at a strategic choice under the manifestly unreasonable standard, the Safarian standard, I guess under Commonwealth versus Pelican. The other side of the coin is the substantial risk. So I guess what I'm getting at is it's a difference maybe between substantial risk and substantial likelihood. So it makes sense for the trial judge, and there was the motion judge, pardon me, and there was conversation about this at the hearing that the motion judge presided over on this motion as to what the standard should be. And the judge asked, can you point me to any case law? Counsel could not, and I think that's because in this case, actually, the manifestly unreasonable standard is what applies.
But would it matter for us? Because we're going to look at whether there was regardless of what the motion judge did, we're going to independently consider whether or not it was manifestly unreasonable and whether it was a substantial likelihood. So even if the court below used the wrong standard, would that affect our review?
No, it wouldn't, Your Honor, and the defendant loses nothing because this court applies the substantial likelihood standard. So I think maybe I'll just leave it there. There was no abuse of discretion in the motion judge's denial of this motion for new trial for all the reasons that are set out in the motion. Defense counsel's decision to pursue...
Okay, but there I think you're wrong. I don't think we review for abuse of discretion because 33E requires us to do something more than that.
Well, that's correct, Your Honor, so perhaps I've misstated that. It was not manifestly unreasonable for trial defense counsel to go forward with a third-party culprit defense in lieu of a defense based on mental impairment and voluntary intoxication. When counsel stood up, counsel mentioned the blood alcohol level, the fact that the hospital records showed that the defendant had, I think it was 4 hours after the crime, or at 4:23 when he was at the hospital, he had a .096. He was also positive for cocaine metabolites. It's unclear, though, extrapolating back, the defendant said, and counsel mentioned, that he drank beer after the crime. So it's unclear what amount of drugs was in his system, how much cocaine he took, when he took it, how it affects him. He had mentioned in some of the medical records in the impounded record appendix that it took a lot of alcohol for him to even begin to feel intoxicated. So there were problems with the voluntary intoxication. Counsel's also not making an argument under Kolinovich because it's clear that trial defense counsel here had medical records. I've reorganized them chronologically, and counsel had enough records in order to be able to make a determination that going with the third-party culprit defense was the right way to go.
There was no affidavit, correct?
There's no affidavit in support of the motion for new trial by trial defense counsel. I would suggest, Your Honor, that I know in the case of Commonwealth versus Martinez, which is cited in the brief, that the appeals court concluded there that the court may draw an adverse inference from the fact that there is no affidavit. And I would suggest here that the reason there was no affidavit is because a truthful affidavit from trial defense counsel very likely would have undermined this motion. I say that because
And there's no affidavit from the defendant saying, I wanted him to assert intoxication defense.
the defendant's affidavit is at the very end of defense counsel's record appendix, and I can't recall exactly what he says. He also has an affidavit from his mother setting out that the mother got calls from him from the clinic. She would hear him walking around talking to himself. She was concerned about his mental state. But in the file, trial defense counsel did a good job of applying for motions for funds. He got funds for a psychologist. That was Dr. Eric Brown, who testified at the hearing on the motion to suppress. And ultimately, Justice Tuttman rejected Dr. Brown's opinion that the defendant couldn't knowingly, voluntarily, intelligently make a statement. So trial defense counsel is in this posture where these statements of the defendant that show that he's cogent, oriented, aware of what's going on, kind of exculpating himself, are all coming in.
Was the motion for funds limited to the statement, or was it in the motion to suppress, or was it more broad?
The motion to suppress was to suppress, I believe, all 5 of the statements.
Maybe I'm not being clear. When trial counsel moved for funds from the court,
Yes, Your Honor.
did he do so to have him examined for the purposes of the motion to suppress, or was it more broad than that?
Thank you, Your Honor. There were a number of motions for funds for the psychologist, and I don't recall if the affidavit in support of the motion details that they're needed for that. I assume that it was because Dr. Brown testified. There were subsequent motions for various experts, motions for payment of experts to explore mental state. And I would draw the court's attention to what was filed as paper number 4. It's defense counsel's motion for funds for a psychiatrist, where trial defense counsel writes, there are complex mental health issues which the defendant's psychiatrist, Dr. David Rosemarin, has thoroughly researched and investigated. The exhibit attached to that shows that Dr. Rosemarin had made phone calls both with trial defense counsel and the sheriff's office, had driven to Billerica, and that was at a time that the defendant was being held at Billerica after he was discharged from Bridgewater. So the trial defense counsel was, it looks like he consulted with a psychiatrist regarding the defendant's mental state. The lack of an affidavit here, I think if trial defense counsel had submitted an affidavit, it might, and Dr. Rosemarin never testified at trial. There was no report, and the court's aware. It was a third-party culprit defense here, not a defense based on mental impairment or voluntary intoxication. So I think it's a fair inference based on what's in the record that trial defense counsel's affidavit would have said something like, I consulted with Dr. Rosemarin. Dr. Rosemarin told me that the defendant was criminally responsible, didn't suffer from any mental impairment, wasn't voluntarily intoxicated by drugs or alcohol. And for that reason, I would suggest it's a reasonable inference that that's why no affidavit was submitted in support of the motion for new trial. And I would just briefly touch on the reason why mental impairment intoxication was not a substantial ground of defense. And as mentioned before, I mentioned before that the statements, and Your Honors mentioned, the statements to the first responders, the individual who was the paramedic who treated the defendant when he arrived shortly after the phone call, the officer Parks, Hudson Police Officer Jonathan Parks, who rode in the ambulance, and then subsequent statements made to the police all showed that the defendant was oriented, he was responsive. One police officer testified that he was, quote unquote, completely coherent. And that would have just been inconsistent with the mental impairment intoxication defense. I'm happy to respond to any other questions.
Can you briefly discuss the defense expert on blood splatter?
Yes, Your Honor.
Did you discern anything good that emerged from that for the defendant?
Well, I think Paul Kish was the defendant's expert on blood spatter, and I can't exactly recall his testimony. What he did testify to was that he could not say whose blood was the source of the spatter. So there was blood spatter, and I think it was the Commonwealth's expert who testified that blood spatter occurs when there's a pool of blood and an impact, and that it would occur if the person was within 2 feet of where this happened. And defense...
So that it could have been his blood? I'm just trying to understand.
Well, yes, Your Honor, and in fact, that's what defense counsel argued in his closing on October 16th of 2012, at transcript page 13. He argued, we don't know how it happened, and the experts couldn't say how it happened. Defense counsel argued this could have happened in a number of different ways, and possibly it could. And as the court is aware, this third-party culprit defense wasn't an airtight defense. It wasn't a perfect defense, and it didn't have to be. All the defendant had to do was to show enough, and there was ample evidence, as Your Honor has recited, regarding this individual, Jonathan Gonzalez. There were substantial links between Jonathan Gonzalez and this murder.
I get that part of it. How about the fingerprint, the fingernail, his blood under her fingernail? Was there any attempt to sort of undermine that?
Well, Your Honor, the way that defense counsel dealt with that issue was to argue that the statistics regarding the YSTR testing of the DNA from the scrapings from the victim's fingernails, that was only found in the victim's left-hand nail. The defendant was the major profile, and the probability of the randomly selected man having a consistent profile was very low. One of them, it was 1 in 2, and the other, it was 1 in, I believe it was 157. And so defense counsel argued this was really non-evidence. One of 2 men could have this profile. And when compared with the other STR statistics, which are 1 in quintillions, it really looked like it was very small. If there are no further questions, I would close and just urge this court that there is no basis for relief pursuant to 33E. I'd ask that you affirm the order denying the motion for a new trial and the judgment of conviction for the murders of Angel Ortiz and Tricia Bennett. Thank you.